Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle, and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 91 of the DWI Guy podcast. On today's episode, we are continuing our Masters of DWI series with James Davis. James was on the last podcast, episode 90. If you have not listened to that episode, that is kind of the backdrop for today's episode. It also includes James's biography and a little bit of information about his experience. So please go back and listen to that episode before listening to today's episode. We also discussed or had a conversation with James's son back on episode 50, James Davis II, back on episode 50 about checkpoints. James Davis is a great attorney in and of his own right. So go back and listen to our guest today's son on episode 50. But very much looking forward to sharing with you the conversation today. James, who has over 100 jury trials under his belt of all different sorts: civil, criminal, serious felony, murder cases, robbery cases, tons of DWI casework, but also on the civil end, medical malpractice, personal injury cases, alienation of affections, a lot of different jury experience that James brings to bear today, and incredible preparation by James in helping us walk through his method for handling a jury trial. So very excited to have James Davis on the podcast today. James also shared with me a copy of his checklist for jury cases, and we will include that checklist. It's his voir dire checklist. We'll include that checklist in the notes on the blog page for this episode. So go to our website. If you are at another location listening to this episode, go to our website if you are interested in seeing that questionnaire, that checklist that James has prepared for voir dire. It's an incredible conversation getting to listen to James today talk through how he handles a jury trial in Superior Court. So looking forward to sharing it with you. Hope you enjoy. In terms of your trial preparation for a jury trial, and again, this may not really be applicable to many of the trials that you've done where it's been a felony and it's gone straight into trial, but on a district court DWI case that you appeal after a guilty verdict or a plea, you appeal to Superior Court for trial. What changes at that point? What are some of the things that, as a result of entering that appeal are now kind of different in terms of your perception of the case?
Well, the good news is most of the time I've had a trial run in district court. And so I kind of know what the officer is going to say. They're not going to really say anything different.
Yes, that's really helpful.
Yeah, that's really a good thing. And so I have those notes. The second thing, though, if I believe maybe respectfully the judge just got it wrong, or that a jury may do better, or in my analysis, it is probably a case that we could win, then I am just going to, at that point, make sure that I get all the evidence from the officer. That is what I've learned over the years. So if there are videos, if there are statements, a lot of times they don't give you everything. There are accident reports. They don't give it to you. There are internal documents. They don't give it to you. And then they go up on the stand and all those things are up there.
Right.
So I just want to remind people that when officers go to the stand, I have learned over the years, lots of times I didn't get everything. and just remember the rules of evidence. I ask them whether or not they've reviewed their notes before their testimony, and then I say, do you have some notes in front of you? And I will routinely walk up there and look at every single note, even in a jury trial, so that next time they'll give me all their notes, and the jury knows that I'm being studious, and they also know that I'm learning right at that moment. So they understand that and appreciate that. And they might think that's a little unfair, right?
Right.
That I
That's
didn't get
so
that
true.
material in advance. So I would say just do your due diligence on all the videos, all the officers, get all of that, ask for all the reports, and then use some of those techniques at trial, because that can work to your advantage.
I really love that point about the jury in terms of how first of all, I think that that's a good point, practice point, whether you're in district court or superior, because you might be shocked what you find in that file. I mean, whether it's an additional document you never saw, or, some sort of handwritten note that is in the file. Again, you might find some pretty helpful information that you weren't expecting was present. But in terms of that jury point, I think that's so powerful. And again, some of these things that are a little bit different in front of a jury, because the jury doesn't know how this is supposed to go. They don't know how the discovery is supposed to go. They're making assumptions about why this case has been set for trial. What may have been offered. Does this mean, some people on the jury may know that there was a district court trial already. Some people may not have, or at least think that there was a district court trial because that's why it's here in superior from past experience or whatever it might be. But again, they're learning a lot of this as they're going through it. And so like you just said, the fact that it's not apparent that you were provided all of this information before court is really something from a jury perception that is, again, it's not just the facts that are getting presented. Is this whole process fair to your client? So I think that's a really powerful point.
Well, just to be perfectly frank with you, I'm so steeped in the behavioral sciences, as well as rules of evidence and rules of procedure and rules of discovery. I'm always playing to the jury. So yes. The fact that I'm going to get up and stand up, and Your Honor, may I approach the witness and walk up there and give deference to the judge, be polite to the officer, but it demonstrates you have a command of the courtroom, that you're not afraid of the participants in there. It all meshes well if you use these techniques well. So I think it sort of gives you an imprimatur of, you have some command, as well as you are fair. You're trying to learn any other evidence out there and representing the client. I just think it all works well.
Yeah, totally agree. Yeah, and I think that just this sense of playing, and it's not even just showing this respect to the jury. I feel like one of the things that you have preached so frequently in CLE is, my role in the courtroom somewhat is as a educator, right? I'm trying to educate the judge, educate the jury, and maybe let the witness educate me at the same time, kind of allow whoever's testifying on the witness stand, whether that's an officer or a defense witness, to be an educator. But I feel like that, role of educator really is an important role, because at the end of the day, you're basically saying, jury, I trust you with this information. I trust you with the facts. I trust you with the law, that you're going to go back and make the right decision. I'm not trying to, pull the wool over your eyes. This is about getting things right. And the way that we do that is to communicate effectively about what specifically happened on this day, so that you have that in your power. And the judge is going to educate you on the law. He's the one that's in charge of all this. And we want to make sure that you have all those things at your disposal as you're going back into the courtroom. I feel like the amount of trust that creates with the defense counsel, who I think a lot of times the jury is looking at like, so what is this guy going to lie to us about? When is the this moment of trying to fake your way into a not guilty verdict going to happen? That I think then kind of goes away, where it's like, well, it seems like he's just trying to help us understand what our job is.
Yeah, you really just hit on some key things. There are so many, again, these behavioral studies, the National Jury Project. If you realize that more than 2/3 of the juries believe when they're seated that your client is guilty, uh, about 2/3 of them, just under that, believe that your client has to explain his innocence, that he has to prove his innocence, and a variety of other. You're also seen in the same light. The defense lawyer is also seen in the same light. So how you start a trial, and I have this method that I use in jury selection process that sort of teaches universally the group theories and then works down to individual theories. And you try to show that you have, again, a command of the courtroom, that they believe that the judge is the most important person in the courtroom and is the most knowledgeable of the law. And so if you'll use that internal belief system to your favor, and I do that very early in the jury selection process to sort of give the judge all the authority, but show the jury why they have nothing to fear, and how the judge is going to tell them everything they need to know. And the only thing they need to do is come and use their life experience and common sense. And if they have a question, tell the bailiff. And, just make them feel they're in charge. It's the judge is going to run this show and win their trust. That's central to success. And you mentioned that at the beginning.
What is that? What does that selection process look like, James? Run us through some of that, if you don't mind.
Sure. Well, I'm watching, the prosecution goes first. So I'm watching whichever prosecutor, and I have many theories. So I'll give you just a few basic ones. One is I'm going to contrast myself with the prosecutor. So if they're just always cutting jokes, or if they're not well spoken, or if they are nervous, or if I am immediately, if they're nervous, I'm going to take the mantle of authority and show them very quickly that I know what I'm doing, and here's why. If they are trying to be funny, then I'm going to give an aura of the august place where we are, and how incredibly important this is as we go through this search of truth. So even in the first 3 minutes, I do things like this. I tell them I'm James Davis. I represent John Doe. John Doe is charged with driving while impaired, and to that charge, he enters a plea of not guilty. And then I will tell them a little about myself, humanize myself to them.
So just kind of break in for anybody that doesn't have, a lot of jury trials under the belt. Normally the way that these things work is you'd be arraigned outside of the presence of the jury, and you're indicating to the court you're entering a plea of not guilty. But I don't think I've ever seen that way of doing that during your intro of your client. I think that is so cool to have the jury know, have them experience that this is your client's plea, that this is how the case has ended up at this point. So I didn't mean to interrupt you there, but I've just never seen that one. I really like that.
I tell them right up front he's not guilty, and then I'll move into I'll just be very human with them. I'll say, look, this wonderful process, this pristine, beautiful process that we're doing is all about the search for truth, and we're going to do that together. We're going to work through rules of evidence and rules of procedure and substantive law, and we're going to walk step by step as you and us search for the truth in this matter. And then I tell them that realize that it's often slow and deliberate. It's not like TV. We're going to truly, justice is often, that's why we don't rush to judgment. We do this slowly and deliberately to find the truth. And then I'll tell them how the ideal jury, you might be perfect on this jury. Sometimes people may not be. They may have had a personal experience. It's difficult for them to hear this, and I'll tell them that they're at the pinnacle of public service and they're the conscience of this community, and that really their role is to protect and preserve this system and to help it work. And I'll tell them the only thing they need to know is to bring their life experience and common sense. And then I will tell them that the judge is the governor, the gatekeeper of this trial, and you need to fret about nothing. The judge will rule on evidence motions and will give us a pattern instruction, and the judge will make this show run. And then I'll tell them about the length of trial. And I do a lot of mimicking of the pattern jury instructions at the very, very beginning. And I will talk to them.
Is all of that, so in terms of communicating that about, your client being not guilty, explaining the court process, explaining the judge's role, is all of that done prior to you asking any questions of the jury? So you're still kind of explaining, or is that coming out through questioning?
No, I do it at the very beginning before I ever ask a question.
Okay.
I tell them, I say, what is, I usually start with just the defendant and then myself. And then I'll tell them, what's this all about? And I tell them, let me give you a few fundamental principles. And then I'll share with them the things about the search for truth and the pinnacle of the legal experience, and how, the judge is the gatekeeper, and they don't need to fret. They have all the power and the authority. And
that's
that
awesome.
I invest them with all, because I'm gonna dovetail that at the end. At the very end, what I try to do is create 12 juries. 12, I isolate and insulate. That's what the Wymore method is. Isolate the 12 of them and insulate them so that they know they are free. I use all these quotes that are, that they're free to, I do it at the very end. I'll just tell you a couple of it real quickly. I'll tell them that they have the right to hear and see all the evidence and voice their opinions and have it respected by others. And they're the reason together, but they're not to surrender their conscientious convictions. And then I'll say, you must in the end decide this case for yourself. And then I'll always tie it together by saying, do you believe the opinions of other jurors are worthy of respect? And I'll ask them directly and individually so that they'll all commit to that 100%. And then I will remind them when I get to closing argument, I use this format. And one of the very last things I do is remind them of their promises in jury selection, how each juror is worthy of respect and that they can come to their own opinion about all of that. So I create 12 juries.
Yeah, that's so powerful. I think, again, just a ton of takeaway from that. I mean, this is not something that beyond a very brief introduction on my end, before starting to ask questions and explaining, kind of what my questions aren't designed to be embarrassing and that type of thing. I really don't give a lot of additional information before diving into the questions. And I think that is just honestly such a powerful approach of explaining the players, helping them to feel at ease in terms of, just being less, guarded already is going to make your questioning more effective, because now it's not like I'm going to make a mistake up here. If I say the wrong thing, I know who the players are. I know what's going on. I have a better sense of what my role is in this whole process. So again, that just letting some of that guard down by the explanation, I think that's so critical to getting straightforward answers in selection, but also establishing some of these principles that you may come back to, whether it's in your opening statement, in your closing argument, whatever it might be. I mean, you've kind of laid the groundwork at that point.
Yeah, and you make a beautiful point. So many of these principles are so important. You just really said be vulnerable. I think that is one of the most. There are 9 different jury selection models. And most prosecutors use a traditional model. They just try to give leading questions and sort of dictate what's to happen. What a beautiful thing to contrast with them.
Yes.
And you can show them how you know the law and how all this system works, but yet you're vulnerable and no one knows all these answers. And you can tell them the law doesn't demand a verdict. The judge will be well satisfied with whatever verdict that you decide. And you can empower them in so many ways. And I usually tell them at the end, after I've tried to do a masterful jury selection, and I'll say, we don't know. Oh, heck, I sure don't know. And I tell them I don't have a crystal ball. I don't know all the right questions. And I usually will ask them the very last question, is there something that I have failed to ask, or the prosecutor? And I never call them the state. The prosecutor. Is there something the prosecutor has failed to ask that you think's important? And I always tell them, if it is, and you don't think you should serve on this jury, just raise your hand. I will not ask you a question. I will simply honor your wishes. So again, I empower them. And I've had people raise their hands and they wouldn't tell me why they shouldn't be on the jury. But the important thing is to deselect the people who will hurt you.
Right.
And if they didn't want to tell you, I give them an opportunity not to tell me, but they don't want to be on that jury, and to get them off.
Yeah, that's powerful. I hope everybody is taking notes at this point, James, because I think that in terms of that model and getting the first opportunity to speak to the jury, right, which I again, the way that you're doing it is so much more powerful than anything I've ever done in the past. It's so amazing in terms of this contrast with the state, because I really think in a jury trial, this is one of the biggest advantages to the defense, is to contrast with this style of, if you're selected as a juror, will you promise to uphold the law? Will you promise to, return a verdict and come to a unanimous verdict? Where do you understand that driving while impaired is illegal? I mean, just all of these, kind of ridiculous questions that are coming out in this very kind of forceful hand from the state's end of things. It is a very stiff feeling, kind of first intro. If you're trying to establish a rapport, and that's how the prosecutor is presenting it so frequently. So to have this explanation, that's going through everything, and to establish that trust of, again, I want you guys to know that you're in the driver's seat. The state is not going to, or I'm gonna try to follow you here, James. The prosecutor is not going to demand something of you. I can't demand something of you. You are the people in the driver's seat is so powerful. And then just that focus, and this is, I think, true also in district court, but with greater emphasis in superior court, in jury trials, is the terms that we use. The referring to the result, not as the result, but as the estimate, right? Referring to that, constantly as the estimate that the state has given you, referring to the state as the prosecutor. Those things really make a difference. I think using the right language is so important. This idea of the machine, right? Using specific words whenever you're talking about whether it's the officer, the estimate, again, the prosecutor, that really is communicating something to the jury. And if you're consistent about that, it will have an impact.
Oh yeah. I mean, I think you're really nailing it well. And, one of the things that I want to say, there are so many things to say. I just want to encourage people to look up and read some of these treatises or read some of these CLEs on jury selection. But think about this. I actually, in my first part of jury selection, I mimic and I mirror much. What did I just tell the jury? I just told the jury that the judge is the most powerful person in this courtroom. They're the governor of this trial. They're the gatekeeper of everything that happens. And then when I've said that, then I take their language in their pattern jury instruction. We should do that because it has all this beautiful language about how they're to approach cases with open minds and free from bias and from prejudice or sympathy. And I often use the highest aim instruction and tell them they have no enemy to punish and no friend to reward, and just a duty to find the everlasting truth. And there's this beautiful language that talks about your
and are you, while you're giving those or echoing those instructions, are you communicating that those are coming from the judge's instructions? No. Oh, so you're just putting that out there, and then they're going to hear it again from the judge, who's going to be basically saying the same thing that you said earlier.
Yeah, I look for opportunities. So maybe the juror's nervous, or the juror is kind of favoring the state in one of their responses, and I'll tell them, I say, look, what you have to understand here, this is your contribution to our democratic way of life. You will become an officer of the court. And I tell them one of the obligations of citizenship is, if your guarantee that if chance or design brings you into a civil or criminal entanglement, that your rights and duties and your liberties will be safeguarded by the same standards of justice that you give here. And I mimic lots of this language when the opportunity arises, because I want them to realize, oh, my life's at stake. What I do here is exactly what's going to happen to me. And then what happens is the judge comes right behind you and says all these beautiful quotes that you've just said. So then in the mind of the jury, they're like, this guy knows what he's talking about.
That's awesome.
And all I did was just repeat a good bit of what the pattern jury instructions say about how they're empowered and what their duties are. And so I strongly recommend, I've never seen anybody do it. And I'm encouraging all of us defense lawyers, use that language.
Yeah, that's so cool.
Echo. Yeah, it's beautiful stuff.
It is. I mean, the language itself is beautiful, but the reason I think that is such an effective means of communicating that you know these issues is that because it is worded so specifically, they're not going to miss it when the judge says it again. I mean, you know that they're not going to be. If you're using the language from these instructions, again, it's beautiful language, so it's not going to sound weird or outdated or anything like that. But then when the judge says it again, they're gonna be like, well, he literally just said that exact same phrase. It'll catch their ear because it's so uniquely worded.
And you're exactly right. So what I'm trying to help you and everyone is, if there's so many little techniques, that's just one.
Right.
But jurors basically decide, let me give you, if I could, one little nutshell summary that I often tell people. Because when you should profile your jury. And I tell people, here's one little theme that I think encapsulates something so important if you want to pick a jury. I use this lifeboat illustration, and think about women, men, and children, various ages on a lifeboat. They're all starving. They're all about to die. Who's going to live? Well, in the very end, in human nature, there will be the honorable people who will sacrifice themselves. But generally, jurors save themselves. So if you think about, because they all want to live, right? Everybody wants to live. So if you'll think of it this way, if I can find characteristics of my defendant or my witnesses that I'm going to put up there, and I know what those characteristics are, and if I find those same characteristics, ex-military, they work this type of job, they did this, they have 3 grandchildren, whatever it is, same characteristics. If they can identify with that person, they will subconsciously see themselves. Jurors save themselves. So just another technique.
No, that's so cool. Again, I think in terms of building the right narrative in, right? One question is, well, how do you get all of this? How do you get these characteristics about your client in? Maybe you can do that partially through the introduction, right? Of, this is my client, Joe Smith, lives here in Nashville, didn't know James. I mean, how do you build that in? Is it through the evidence, through the introduction of your client? How do you get them to know these specific identifying characteristics about your client?
I'm probably going to have to know that I'm going to have to put my client up.
Okay.
And the one thing about most DWIs, sometimes you're not going to put the client up, but realize with juries, almost always, even though the pattern jury instructions say the defendant has the right to remain
silent, they want to hear from them.
They want to hear from them, and you're not to consider. It says all that. They want to hear from them. So in the majority of DWI cases, I'm probably going to put the defendant up. And here's another key point. Character evidence does not work in front of judges. Character evidence works beautifully in front of juries because juries believe in propensity. So if they're honest people and you put up 4 people that are going to match the profile, old, young, black, white, all of this, diverse populations, and you're going to match profiles of different people on the jury. And if they say, oh, I've known him 15 years, I've known him all his life. Yeah, he's honest as the day is long. Jurors are heavily impacted by that, by character evidence. So again, I just share that. So how am I going to get the characteristics up? Put the defendant up and then ask him. They have the right. If a prosecutor ever objected, I'd say, Your Honor, they have the right to know this individual and know something about this individual to assess his credibility. Remember, credibility is an issue on every witness.
Yeah, that's
the right to know something about him.
That's such a powerful way of overcoming an objection based on relevance or whatever it might be. I mean, that's such a important part of the process. And most of the time, with the officer, I guess they're not doing that specifically in terms of bringing in their character, but they already are doing that to some extent with all of the training and everything that they've gone through. It is somewhat of a character assessment. So, right. Your client should have the same opportunity on their end of things. I think that is such a powerful thing, particularly in a criminal case where there are either assumptions because of the fact that somebody is charged with driving while impaired about what their character is like, or the way that the officer is going to talk about this person in testimony, not only criminalizes your client, but demonizes your client to a certain extent. And I haven't had too many cases where I have called my client as a witness, but I think if you do that, you do have such a powerful opportunity to show the person for who they are, to let the jury get to know this individual, because now, I'm no longer just judging a number, right? 19 CR 50256. It's like, okay, well, Joe's talked to us now for a little bit of time here. And so, I feel like I've gotten familiar with who he is, the circumstances that led up to this. I mean, humanizing your client, again, it's State versus John Doe. I mean, you've got the opportunity in terms of personalizing things. If you're on the John Doe side of things, that's our advantage.
Let me, you're exactly right. Let me just throw a couple more things out real quickly. If you're going to put the defendant up, never give your opening statement at the beginning. I never give an opening statement at the beginning. I always reserve the right. Your Honor, we respectfully defer our right to an opening statement at this time. Why? Because I'm not going to tell them what my case is.
Right.
And I'm not going to let them do anything in the prosecution. I'm going to wait and see whether I'm going to put up evidence or not. So never do that. I also would say to you, I lost my train of thought on that. I apologize.
But just real quick on that. So even if the state gives an opening statement, then you'll in those cases where your client is likely going to testify, you just will be, how do you communicate to the jury that you've kind of, or do you not communicate that you're not giving an opening statement?
They'll ask, the
Okay.
judge will ask.
Okay.
And I just stand up and say, Your Honor, the defense respectfully defers
Okay.
the opening statement at this time. And then when I get to the closing argument, I always start with this phrase. I look at the jury and I say, and now for the rest of the story.
Yeah, that's awesome. I love that.
Just like Paul Harvey, right? I always just say, and now for the rest of the story. And I quickly lay out all these facts, and it's efficient compared to how the state did it. We're going to put these witnesses up. We're going to put them up efficiently. And they're always, if you're efficient with it and put up your key points, the jury really, really, really likes that. And that's just a wonderful way to do it. And now for the rest of the story. I also want to say something about jury selection. This is so important. If you have a bad facts, draw the sting. So let me give you an example. I tried a DWI. My client blew a 30. That's right, 0.30. And yeah, true story. And so we're doing jury selection. And so I tell the jury what? Oh, by the way, he was an older man. I said, Mr. Jones blew a 0.30. That is a 0.30. And I said, I'm going to let that sink in for a moment. And the jury was looking at each other. And one of these people on the jury turned around and looked at me and said, well, why are we here? and I laughed out loud. We all laughed. And I said, because we think he's innocent.
That's funny.
And the jury came back not guilty.
That's awesome.
So draw the sting. If you have bad facts, they could object about staking out. Please make sure that it has to be an uncontroverted point. That is, the state knows that's the evidence. You know the evidence. It's not controverted. But you just say, given that fact and knowing that you will hear all the rest of the evidence, can you still presume he's innocent? And they'll go, what? But you've got to let that sink in psychologically early in jury selection. So by the time you get 2 more hours into it and you start the trial, they've already let that shock sink in, and they know there's a real trial to come. So I strongly tell people, draw the sting. It works.
It works. And I think that the beauty of that is that you're not going to draw any objection from the state in terms of they're not going to be upset that you're trying to introduce kind of factual information into the jury selection. They're going to be more than happy to let you talk about that. But I think it is. I think if you pull that out and kind of take the wind out of the sails of the state by putting that information out early, that's so powerful. And I also love your response to that question, because I think so many of us, that are in that position might say something to the effect of, well, you've got to hear all of the evidence. And, so to just come back and say, well, because we think he's innocent is so powerful a response. I really think that again, in terms of that behavioral way of looking at how the jury is action, if you don't believe in your client's innocence and the jury gets any sense of that, you're dead. I mean, your client is dead in the water. They might as well not be in that courtroom. I have this really good ability at being a cornerback that is in the courtroom, and that if the state beats me with a home run ball, and they score a touchdown, I just come back and it's like, well, we're going to get them the next time. But I always believe that I'm going to stop them. The mentality is that, when I'm up there in front of the jury, I feel like I'm going to win every case. My wife I'll talk, about a case with her, non-specific in terms of the facts. And she's like, you're never going to win that case. And I'll be like, I think we are. I think we're going to win it. Sometimes we do it. Sometimes we don't. But I think that is a really important thing to communicate to the jury, whatever it is, but whether it's by answering a question like that, the way that you're talking to your client, putting your hand on their shoulder, the way that you are impassioned in your closing, whatever it might be, that you can communicate to the jury, my guy didn't do this. And I believe that if they have got trust in you, which you're doing already by, explaining the people in the courtroom, the search for truth, the judge is the one that's running the show. You guys are here with all the power. All of that is about building trust. If you then are able to communicate very strongly that you think your client is innocent, they have a reason to believe you about that. So I think that is such a powerful, kind of off the cuff response, but it's a really powerful response.
Oh, thank you. Yeah, I agree with you 100%. You have to exude and believe that your client is innocent. And just remembering that you take blows throughout the trial. I just want to emphasize, early on in my career, I was afraid to do those things. I want to openly say that.
Yes.
Be vulnerable. I was afraid to do it. And what I want you to realize is that I devalued the emotional attenuation that occurs over time. So when I tell them those bad facts, they're going to come in anyway. And when I tell them that and then repair it by saying, now that you know that fact, and then I walk through the presumption of innocence and tell them that this presumption of innocence, that they have to see him clothed in that presumption right now. And I ask how many do, and I make them affirmatively raise their hand. You'll catch the people who don't want to. And then to say, we're going to walk through the evidence. The state's going to go first. And we all know about primacy, right? That has the most powerful effect early. And I tell them that. I say, look, they get to go first. You're not to make up your mind. You're not to do anything until you hear all the evidence. And I tell them they're to look at him presumed innocent all the way through the charge, all the way until the jury goes back, that they must see him as presumed innocent. And then that way I can use the drawing the sting of the bad evidence and make them come to terms with it right there in jury selection, because there's a lot of angst when they hear that. They don't know the rest of the evidence, but it really attenuates over time. That's what I want to share. Please believe in that process, that if you can get it out there and say, hey, we believe he's innocent. There's more. You need to hear the rest of the story. And we'll do this search for truth together. So those principles really work. That's what I want to share.
What is the method that you use for kind of preparing your client for that? Do you tell them ahead of the jury coming in that during selection, I'm going to talk about, what your blow was, or that there was an accident, or whatever that kind of, particularly bad fact might be? What is the way that you prepare them for that?
Okay. Well, let me make sure I cover a couple legal principles, because this is very important. I think everybody knows Harbison.
Yes.
You can't admit to guilt to a crime. And there's also a case that was pretty recent that is Harbison related, that said, well, it's not necessarily IAC, ineffective assistance of counsel, if you admit to an element of the charge. So think about that. We might want to say that, yeah, he was operating the vehicle.
Right.
There's no dispute about this and dispute about that. I think you should have that colloquy with the judge before you do your closing argument. But for purposes of jury selection, you're only admitting a fact. And the fact's going to be the 0.30,
right,
or the fact's going to be, some other bad, uncontroverted fact that comes out in the evidence. Usually not an element, and not an admission of guilt to the crime. So it doesn't require a Harbison inquiry.
Right.
What I do is, when I know those bad facts are coming into evidence, I'm just giving them a piece of a fact, not an element, not an admission to the crime. And then I just tell the jury, I say, you will hear evidence from the state, uncontroverted evidence. That way I don't get an objection. That, John Doe had a wreck and that it was a 3-vehicle wreck. And I probably won't get into whether it was totaled or whatever, but whatever I can say that sufficiently implants in their mind, that's a bad wreck.
Right.
That's what I tell them. I say, now, think about that for a moment. We cannot conduct this trial and we cannot be fair to Mr. Jones if you cannot consider that fact and presume that he is innocent. So then I start to make them digest it and think about it and work through it. And then I spend all this time after I've drawn the sting at these multiple phases, and I'm getting later on in jury selection when I talk about the presumption of innocence, because I want them to realize how that never leaves and how they must affirmatively see him that way. And they must continue to see him that way. And if they don't, they're not right for this trial. And it wouldn't be right for their families or for their children. And that's the way that I tend to walk through it.
Yeah, I like that a lot. In terms of other questions during jury selection that are trying to kind of spell out your case or give a little bit of a forecast of the evidence, kind of start to build the kind of story that you're wanting to tell. What other questions specifically on a DWI case do you try to kind of start building that narrative in through?
You can't go into the facts in the jury selection other than the uncontroverted evidence. So it's going to be very minimal. I may, if I have a bad case, I may mention 3 bad facts because they're coming in. And I'm going to get that bad stuff right out there so that they can think about it. And it might be that this is a case where Mr. Jones blew an 08. Now, know that. But that the law does not mandate a conviction. And then that's when I'll teach them that the law is satisfied with your decision and the judge is satisfied with your decision. And then I'll walk through that. So I've gotten that right out there, because when they're going to hear that instruction, you're going to think, well, it's deemed sufficient. I mean, what does that mean?
Right.
So I am going to, whatever those really bad facts are, I'm going to get that out early and then repair it. Why are we here? Why is he presumed innocent? Why would the defense believe he's innocent? And then tell them, we'll do this search together. We'll do this search together.
Before we kind of move on from jury selection, any other tips that you have to share in terms of effectively conducting jury selection?
Yes, I think that I have it in various groups, and I'll just tell anybody, I have a jury selection sheet front and back, and anybody's welcome to it. It is a compilation of all my jury trials over the years.
Yeah, that's amazing. Thank you so much for sharing that, James. You got so many great resources on your website. We promoted a bunch of them in the past. I steal freely from you frequently. So, but maybe if there's a way for us to either share that or link to that, I'll be happy to do that so we can make that part of the podcast notes. Absolutely. But yeah, definitely want to pass that along because that's gold.
I will pass it on. And really, it's very clear. If someone takes the time to just read through it a few times, they're going to say, oh, I see the system. It's going to make, so I go through this explanation of the process, and then I go through group questions, and I tell them, I'm going to do group questions. And then I go to individual questions. And let me tell you, I do that both for information gathering, but I do it for emotional attachment. So I always talk to every juror, even if I look at Mr. Smith and say, Mr. Smith, how are you today, sir? And I heard all of your background. Thank you very much And then I'll pause, and then I'll say, I don't have any questions. Or I may say, are you good for this week, sir? I'll just build them up and then say, thank you very much, so that they'll know I respect them and connect with them. And then after I do the individual questions, I go to key points. I want to point out there are a lot of subtle things here. Like sometimes people who are supervisors, they're leaders. So one of the questions I always ask, are you a supervisor? Do you supervise any employees? You better watch them.
Yeah, that's really interesting.
Oh, yes. And then just like negotiators and people who are business execs, any type of a negotiator is going to be a leader. Anybody who's a deal maker is going to be a leader. Anybody who's a supervisor is going to be a leader. And then I'll ask them if they know anybody else on the panel, because a lot of times if you don't ask them, they know each other.
That's so true.
And you got to ask them that.
Yeah.
And then I find out about law enforcement, military, rescue squad, because sometimes DWIs, we have rescue squads and we have fire departments, and I need to know if they're affiliated with these folks. And then I go through this process of trial. This is very important because they need to know who's going first and who's going last, and that there are going to be objections, and there may be interruptions of 15 minutes dealing with matters of law, and drawing the sting. And I very frequently do this. Because in DWIs we have officers testify. So I often say this kind of question: do you believe that the testimony of a law enforcement officer, would you give them any more weight solely because they wear a uniform than you would any other citizen? And then what I'll do, if they say yes, and then I'll say, well, not to say that people are not deserving, but we have pattern jury instructions that talk about the test for truthfulness, and they don't talk about wearing a uniform. And maybe we all realize that there are some citizens who are very credible, very believable in all aspects of life, and maybe they're wonderful officers and maybe not. And I just talk through that process with them, being respectful, but getting people to think through, oh yeah, we are all different. And yes, because they wear a badge doesn't really matter. And then I walk through.
I think that specific question is such a powerful question. And it's also very, I love it when somebody actually is brave enough to say, yes, I actually do. I would give an officer more weight, because now you can have the conversation with the jury. To me, it's way, way worse when everybody just is like, no, I think everybody's the same. I'd much rather have there be like a dialogue based on that question, because then you can say, well, Mr. Jones, appreciate your candor about that. Miss Smith, you heard what Mr. Jones said about that. What do you think about that? As what's the difference between somebody wearing a uniform and not, and how their testimony is going to come out? I think that if you can get one person to talk, it's much easier to get other people to talk.
Oh, I totally agree. And that's what you just said, Jake, is a wonderful technique. If you can get people starting to talk, then you're going to get diversity of opinion. And then they know what you want them to say. Right. But people will become more candid. They will become more open once it's broached. And I think that is a wonderful technique. I want to make sure that I tell people, embrace the moment. Engage them immediately when you hear something, because what you want to do is show what's fair and what's reasonable and what our law provides for, and how we can only have this administration of justice if we do that. And so seize the moment, because they're going to hurt you later.
Right. Exactly.
So seize the moment to dive in head first. And I want to encourage young lawyers, older lawyers, everybody, dive in, because that is a wonderful opportunity to go directly to what people are thinking. Beautiful thing.
Yeah, totally agree with that. I didn't mean to derail you.
No. You're not derailing me at all. In fact, I then move with this presumption. I tell them a charge is not evidence. It's merely the mechanism by which we bring people to trial. And then I talk about presumption of innocence. And I often ask them, must you hear from Mr. Jones? The law does not require that. And many times I often explain it by saying, some people speak well. Some people don't. Some people, there are lots of reasons why people may or may not testify. The case may be terrible. I mean, it may be weak. So I understand there are reasons, sound reasons, buttressing these principles of law.
And then I think along that same front, I think you could, one of the things that I think is helpful is to kind of approach it with that same question that you just had used, which is to basically say, who here would like to hear from the defendant? Who here thinks that the defendant should testify? If you were charged with a crime, do you think that you would want to get up and tell your side of the story? And then once they kind of, well, yeah, I would like to, I think I would get up and say very clearly why I wasn't charged. And then, well, you just heard Mr. Jones say this, Miss Smith, what do you think about that? And then once they've all had their opportunity to talk and express their opinions, which then you can use in terms of making any, selection, decisions, but also in terms of just making sure everybody feels comfortable talking about their specific viewpoints. And hopefully then that translates, like you said, in terms of isolating in the jury room, everybody can feel confident going back there and say, well, we disagreed with this during selection, and I'm still disagreeing with you now about how this thing is going to go.
Exactly right.
Down. But then you can still then at the end of that conversation say, well, here's what the law says. And what do you think about then, can you follow the law? I mean, the law doesn't require my client to testify. Do you think that there's going to be even the smallest amount of issue on your end in being a fair juror if my client doesn't testify, despite the fact that he's not required to, and you're not allowed to use that in any way against him? Is there going to be any concern? And some people will say yes, and some people will say no. But again, you still have that opportunity to bring in. But this is where I think we differ from the state, because the state just says, do you understand that, my client doesn't need to testify? And everybody says yes, because that's the constitutional right. But most people are thinking, but he really should say something, So you want to draw that information out before you just kind of get that black and white answer.
And here's a little technique. If you're going to get a group discussion about that, here's my suggestion. Involve as many as you can if you're going to do that. And here's why. And draw them to where they really think that way, to let them tell the truth. And end it with this. Do you think that would, regardless of whether you'd follow the law or not, that it would stick in the back of your mind? There's a case very specifically on point that even if they say they'll follow the law, but it would stick in the back of their mind that they're excludable for cause.
Interesting. Okay.
So it's on my pattern jury. It's on my instructions. I give at the very end these buzz phrases that are very important principles of law. Like if that would substantially impair their ability to hear the evidence, or if they would automatically vote for a particular position. But there are multiple cases that talk about even if they say they're fit to serve, and they'll follow the law, if they say it'll stick in the back of their mind. If you get 3 people to say that, then you move to exclude for cause.
Yeah, that's powerful. That's a great practice tip.
Yeah. And so then I move through this, in the way I tend to finish it is I empower the jury. And that's when I say, look, you're in charge. You have the right to hear and see all the evidence. You have the right to come to your own conclusion. Your duty is to attempt in good faith to deliberate toward reaching a unanimous verdict. Beyond that, it's your conscientious convictions. And everybody is to respect that. And you are worthy of respect. And then I'll say, Miss Jones, do you think Mr. Smith is worthy of respect in his positions? And I'll get them pitted. And they'll all say, they'll say yes. And then if I get, that's when, the most recent DWI I did was a hung jury after 2 days. And I think it's because of those techniques. And I think
that's so important. I think giving as much of that power to obviously the group, but maybe even more particularly to each individual juror is critical to the defense on these kind of cases. I mean, if whether or not you can keep a jury back there longer talking about things based on that idea of everybody's opinion matters, or ultimately getting to a hung jury, I think it's really important to be able to have each juror go back and feel like my opinion matters. There's been so many times where I've talked to jurors afterwards, and they just there's some sort of an expression of, I didn't think your client was guilty, but I just felt bad for the keeping the other jurors in the room, or it was 10-2 or 11-1, and I just I felt like I must be wrong, or so something like that, where it's kind of like, man, I didn't communicate well enough this principle, or part of that is just the jury process. But I think the more that you can give each person that freedom to be able to think what they want and vote the way that they want to vote, that's gonna be so helpful in the deliberation room.
I agree. And I think you have that right, Jake. That sheet is so helpful to people, and I have this in this paper on jury selection, so many little techniques that are so important. If I could say to anyone, if you can just realize, there are phrases in here like, while the lawyers are picking the juror, the jury's picking the lawyer. We just have to realize that we're an extension of the client, and if they have faith in us and trust in us, and more importantly, not just trust us, but like us.
Yes, that's so important.
Yeah, we need to be likable, and that doesn't mean be obsequious, try and be too funny,
right?
Or ingratiate ourselves to them. It means be appropriate, but be humble and be vulnerable, and tell them, I don't have all those answers, and I understand and respect that. I just think it's really important to understand to deselect. If you think, go by people's answers, not by your gut. It is true. If you see physical manifestations, they're jerking their head away, they're looking away, they're sitting with their arms crossed, all these forms of communication. I mean, if they're mean-spirited, then they're mean-spirited to everybody. So, I mean, you've got to pay attention to all of those things. I want you to realize also another little technique: the evidence won't shape the jurors will shape the evidence. That's why you have to pay attention.
That's such a cool way of thinking about it. I like that a lot.
Yeah, it's the truth. The evidence doesn't shape them. They literally will decide who they like and why, and they'll shape that evidence to meet that result.
That's so powerful. That's a great way to think about. I mean, I think even in terms of, again, going back to that, well, because we believe he's innocent, right? Like, that already is starting to shape the thought process of, well, we, again, this attorney has very easily made it look like, put it out there that us asking the question, why are we here, and very comfortable with explaining we're here for a good reason, right? So now already that's shaping who this person is that's sitting next to you. I think one of the easiest things to do in a jury trial, because there's so much going on, especially as a young lawyer. You've got the jury that you're paying attention to, the prosecutor, you're trying to focus on questions that are coming up. Somebody may be coming up and passing a note or whatever it might be. And so there's all of these distractions, and it's so easy to forget about your client sometimes because they're just sitting there maybe they will ask a question, or maybe at the end of your cross-examination, you say, is there anything else that I should ask? Or during jury selection, hey, you turn at the end of all the selection and say, is there anybody that you think would be appropriate to remove from the jury? Do you feel comfortable with these jurors that we're going to keep? But the more that you can incorporate your client into the process, there's two real benefits from that. The first of all is that if it's genuine, if you really genuinely care about your client, that will come across to the jury. The juries as a whole are great people readers. I mean, they're really good at that. That's one reason why I think so often the jury does get it right, is because they're really good at, as a group, perceiving human beings. The second thing is that it also allows your client to walk away, whether it's guilty or not guilty, feeling like they've been represented well. The fact that you kind of were so adamant from the get-go of saying, my client is not guilty, and then within a brief period of time, we're here because we think my client's innocent. That is communicating something to your client about the defense. Again, before any evidence is getting presented, anything is getting laid out, your client is able to perceive that. And the more that you include them throughout the trial, whether it's with, hey, do you have any questions about anything that's going on? Or do you want a cup of water? Or whatever it might be. Again, the more you can humanize your client, going to be really powerful to the jury, but it's also going to, again, win, lose, or draw, have you walk out of the courtroom with your client saying that guy just went to bat for me, just really went, and sometimes you could be the worst lawyer in the world and still have your client, as you walk out of the courtroom, feel well represented if you care about them. So I think it's important because it's got to be genuine. You can't be doing it for a show. It can't be something that this is just, Minnick told me to pour a cup of water for my client, and that would earn. It can't be from that perspective. It's got to be from a genuine perspective. But again, just hearing you say those things, it's like, man, that guy must have felt really well represented, because it's like, he believes in me. James believes in me.
Yeah. Well, you're exactly right. You can't fake that. You made me think of a few more points. And Jake, again, you're giving people wonderful advice. I would suggest always give your client a notepad and a pen. That not only will that keep them occupied, but you can look at whatever jottings they have when you finish each examination. I always say, "One moment, please, Your Honor," and then I look at any jottings by my client. Second point is touch and humanize them.
Yes.
I always put my hand on their shoulder. I put my hand on their leg. I am letting the jury see that I care about them and I'm genuinely invested in them. And I genuinely am not afraid of them. Two quickest ways to lose: if they think your client is violent, or they think your client is crazy.
Yes.
So as nicely as I can say that if they're afraid of the client, we're in trouble from the very beginning. So just humanize them, touch them, talk to them, make that really count. And also, what I do when I do closing, and I have this, just like jury selection, I have this general format for closing, which is, I think, really effective. And one of the final things I do is typically I will walk over from the jury, and I will walk over and put my hand on the defendant. And I will, when I'm talking to them about all these principles in life and in the courtroom, and I'll tell them, I'll say, today is the most important day in Jeff Jones's life. And as you consider these principles, and as you consider all of these themes and points of law that we've suggested, remember that it counts and that it's meaningful. And then I'll walk back to the jury, say my couple of things, and then ask to find not guilty.
Powerful stuff. I mean, that's really powerful.
Well, it just reminds, they have to have an emotional hook. One of the ways that you can win is not just, they're all different, intellectual and everything else, some mathematical. If you run through these juries, we know the percentages about the different types of people, right? But I think you put an emotional hook. And I love what you said, James. I can tell you I agree. The jury's way smarter than all the rest of us in there. There's a beauty to the number 12. They're smart when you have the collective conscience.
They are. No, I totally agree. I think it's one. I mean, it is really why the system works. I really believe in the jury system. It's such a ordinary human beings are extraordinary in and of themselves, but particularly as a group, it's just the collective knowledge that group brings to the table is incredibly humbling. It's no matter who the smartest individual in the courtroom is, doesn't make any difference when put up against that group of 12.
Totally agree. They bring different skill sets, different vantage points. And I've always been amazed. I try to talk to every jury afterwards. I'm always amazed.
You should definitely do that. Yeah. If you don't talk to the jurors afterwards, you're really losing out on, and sometimes, especially on a DWI, maybe in particular, because you might go straight into sentencing after guilty, and then the jury's already gone. Like, I will actually ask the judge, can we just, can we stop for a minute so I can just go speak to the jurors and they can get out of here? And normally judges don't have an issue with that. That's not something that there would be a concern about, but I don't want to miss that opportunity to speak with people before they get, dismissed and on their way.
It's one of the greatest educational tools for me in my career, is listening to what the jurors say, always asking them.
Yeah.
I always quickly tell them, thank you so much, regardless of the verdict.
Yes.
However it went, thank you so much. And then I always ask them, I say, look, no pride, all to the side. What did you like? What did you not like? And I'm very interested in what you didn't like.
Right. Yeah.
As well as what you liked,
right? That is the more helpful information.
Yes. Because usually they're quick to tell you, and you might know the things that they liked, but it's if some point of fact they didn't like, or maybe they thought that the expert was particularly convincing. I think how you address experts is incredibly important, as well in jury selection, as well in the performance of the trial. Also another important issue.
Well, James, I think we could probably have a multi-semester course in terms of all of your knowledge on how to deal with juries. And so I have to get you back on the podcast. But before we sign off, maybe if you could just leave us with this, in terms of trial tips or practice tips for young lawyers, what would be anything that you would advise young lawyers that are early on in their criminal defense career?
Well, I have a couple of comments at the beginning of almost all these seminars, and I think I'd say those to the young lawyers. But let me just sort of say, try to stretch yourself daily. Try to develop relationships with officers, and as you examine officers, realize it's not adversarial with them, that you're just asking fact questions, and they'll respect that. I would also say, always be very candid, very honest, very truthful. It's ethical. We're supposed to tell the judge case law that's against us as well as for us. Have a reputation as a truth teller, no matter what. I would also say, then I'll just quote some of these things. Just kind of think about how you practice. It's kind of a mosaic, a work of art. I think that preparation is critical. If you will prepare, then you can be spontaneous. I also think that you should think through the evidence. I once had, in fact, one time I went to a seminar and there were like 7 Superior Court judges and there were only 12 participants. And one of the piece of advice was to read the rules of evidence several times a year. I do that. And I try to read the cases to interpret them. And I would say, know the rules of evidence and know them well. And the only way that you get better at it is by trying trials and then applying the rules in the context of the evidence. I would also say, be vulnerable, be courageous, and don't be afraid to try it if you think you have a chance at winning. That's what I would say.
I love that. Much of that is great advice for me individually, but also just kind of thinking through it, this idea that preparation kind of allows for spontaneity. I totally agree with that. I think that is one of those places where maybe even just going back to my comments earlier of, not being scripted with the questions that you ask. There's no problem with being scripted with those questions and thinking through individually everything that you're going to ask the officer. And if you have that as your framework, now you can go in thinking, okay, well, I'm not going to miss anything, and I can have this kind of free flow of ideas. It doesn't mean just walk in and let's wing it, which I've been guilty of many a time in my own practice and preparation. But the more that you prepare, the more that allows for that kind of creative, in the moment fluctuation of how you're going to present evidence or what the arguments that you're going to bring to bear on. If you've got that background and you put in the work, it's going to be a lot easier to get creative with it. But all of those were such powerful practice tips, James. It is an absolute honor to have you on the podcast speaking to the audience. I personally am very grateful for this conversation. I know the audience is going to love having heard from you. You've been kind of since day one of the people that I've looked up to in practice. And it's just a real honor to have you on and be able to have this conversation with you.
And Jake, I just want to mimic and mirror that back to you, because I want to tell the audience, I might be one of the older older lawyers, but I want you to know that I listen to these podcasts. I have learned by listening to them. Some of them have been off the chart, and just the pearls of wisdom and new information and really smart advice and strategies. I am a better lawyer from listening to your podcast. Thank you, Jim.
I appreciate that. That is a real, a real testament to the person who you are, but also how do you get to be a great trial lawyer? You never stop learning. And that's, something that you have really embodied in all of the CLEs that you teach. It's always about, hey, what new tool, what can I bring into the conversation? And you're obviously doing a lot of continued research on these issues and putting out the different great papers and everything that you continue to let us use. It's such a powerful thing to kind of see that always be learning mindset. So yeah, everybody out there, keep learning and get to trial.
Amen. I love to say we're all the same. Let's go get them.
That's awesome. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.